Welcome, everyone, and especially to our esteemed justices and our international audience. This is the third in our series of comparative constitutional law conversations, comparing the role of the highest courts in the world's two largest democracies, India and the United States. Both the United States and India have an independent judiciary, and their Supreme Courts are among the strongest in the world. This conversation series is a collaboration between the Georgetown University Law Center and the Society for Democratic Rights, which was started by two Georgetown Law alums in New Delhi. I want to especially thank the mastermind of this series, Vibha Datta Makija, LLM, class of 1992 Georgetown Law, who is a senior Supreme Court advocate in India. For her partnership was critical to making this event possible. Today, we are incredibly honored to host the Honorable Chief Justice of the Indian Supreme Court, N.V. Ramana, alongside Honorable United States Supreme Court Justice Stephen Breyer. Justice N.V. Ramana was appointed as a Justice of the Supreme Court of India in 2014, and he was sworn in as the 48th Chief Justice of the Indian Supreme Court in April 2021. Chief Justice Ramana hails from a Telugu-speaking agrarian family from the state of Andhra Pradesh. Chief Justice Ramana has actively advocated during his tenure on the court for gender equality and representation in the judiciary. As the chief patron of the National Legal Services Authority, he has been vocal about access to justice by removing colonial vestiges still existent in the law. He's upheld these freedoms through his judgments as well. We're so honored to have him with us for this conversation. Justice Stephen Breyer was born in San Francisco. He is a graduate of Stanford, Oxford, and Harvard Law School. In fact, he taught at Harvard Law School as a professor and at Harvard's Kennedy School of Government for many years. In 1980, he was appointed to the United States Court of Appeals for the First Circuit by President Jimmy Carter, before becoming chief judge in 1990. In 1994, he was appointed a Supreme Court justice by President Bill Clinton. And Justice Breyer has written many books on a number of topics, from administrative law to the role of the court. Most recently, among his books are The Court and the World, published in 2015, and just in 2021, his newest book, The Authority of the Court and the Peril of Politics. The conversation today is going to be moderated by our own Georgetown Law Dean, William Traynor. And just before we begin, I want to invite all members of our international audience to please send questions through the Q&A function on Zoom. And now I am delighted to hand over the program to our host, Dean Bill Traynor.
Thank you very much, Dean Sunder, and welcome to Chief Justice Ramana and Justice Breyer. We are so delighted to host you both at Georgetown Law for this historic conversation. And we're proud to co-sponsor this comparative constitutional law series with the Society for Democratic Rights, which is an initiative of two Georgetown Law alums in New Delhi, Vibha Datta Makija and Kashisha Neha. So thank you to them. And particularly thank you to Vibha, without whom we would not be here. They've worked hard in partnership with our Associate Dean for Graduate and International Programs, Madhavi Sundar, from whom you just heard. And I understand that Chief Justice Ramana and Dean Sundar's family both hail from Andhra Pradesh. Her grandfather was the founder of the Andhra Law Times. What a testament to the dynamism of our global legal culture. And this is just so perfect that they're both here today. So to begin, both the Indian Supreme Court and the US Supreme Court are making history with their recent appointment of women justices. So I'd like to focus on that historic development as we begin. So let me begin with Chief Justice Ramana. As the Chief Justice of India, you have been very vocal about inclusiveness. You've strongly advocated for greater representation for women in the judiciary. In fact, you've proposed affirmative action for women as judges and law officers, as well as in legal education. Empirical data suggests you've achieved considerable success in advancing this agenda. In your tenure as Chief Justice, 3 women justices were elevated to the Supreme Court of India, and one of whom will become the first woman Chief Justice. And we read reports that for the first time, a legal professional who is openly gay was recommended by you for elevation as a judge of a constitutional court. So, 2 questions to begin. What are your views on inclusivity in the judiciary, and how important is it to carry forward in the Indian context? Mr. Chief Justice?
Let me first congratulate Honorable Justice Stephen Breyer. You have contributed a lot to the American jurisprudence, and you have a glorious innings for, I think, more than 40 years. And it was remarkable that you have sacrificed your tenure to unleash major transformation in the US judiciary. I congratulate Justice Breyer. Now, coming back to the question that about the Indian judiciary, the inclusivity and taking up the appointments, etc. I must say that you are all aware that our Supreme Court was established in 1950. It is 72 years old. It is relatively young. India is known as the world's largest democracy. We have one of the largest judicial networks in the world. The first woman judge was appointed in the Supreme Court after nearly 40 years. We now have 4 women judges. This is the highest number so far. I know it is not enough. I expect more. I'm happy that the recent appointments and recommendations have generated a lot of discussion about the inclusivity. In fact, I borrowed from Karl Marx in one of the meetings organized by the women lawyers in Delhi to say that women of the world unite. You have nothing to lose but your chains. This resonated well with the people. They welcomed the diversity. For me, inclusivity does not stop with having more women judges. Our population is nearly 140 crores. India is home to around 120 languages and thousands of dialects. More than 4,000 communities and more than 700 tribes. It has 28 states and 8 union territories, each having many regions with distinct characteristics. This social and geographical diversity must find its reflection at all levels of judiciary. With widest possible representation, people get to feel that it is their own judiciary. Diversity in the bench promotes diversity of opinions. Diversity enhances efficiency. People from different backgrounds enrich the bench with their diverse experiences. A judge from rural background understands the issues of rural India better. A judge from a particular region understands the issues that are better. A judge from marginalized section understands the issues of marginalized better. I'm very happy that the outlook of my collegium members is very progressive. In the recent appointments, we could select judges from 9 different states, and out of them 3 are women. I know we have many miles to go, but a beginning has been made. This is my answer.
Very good. Thank you very much, Chief Justice. Justice Breyer, actually, let me see if you have any thoughts on the Chief Justice's statement. And then also I'd like to ask you, your retirement has secured the historic confirmation of soon-to-be Justice Ketanji Brown Jackson to replace you on the court, to become the first African-American woman on the court. And she spent formative years clerking for you. How do you feel about her confirmation?
How do I feel? I feel great about her confirmation. That's terrific. She'll be very nice person, very decent person, highly intelligent. She'll be great. That's good. And I want to thank the Chief Justice for his kind remarks about me. And I want to thank him for giving us this opportunity to speak to him, because I think it's a great thing for Georgetown and for this country to talk to judges in other countries too. And the Chief Justice of India has a court rather like ours in many respects and has some of the difficulties that we have. So we can understand each other. As far as women are concerned, when Ketanji is here, there will be 4 out of the 9. And that does not mean the problem is over. What you want really is you want to be like this. There are women on the court. Yeah. There are 4 out of 9. Yeah. Really? Oh, yeah. I guess so. See, normal, natural, comfortable. Hey, what's the problem? When we've reached that stage, good. And it's not just with women, it's with minorities, it's with all kinds of people. Of course, they might be somewhat different backgrounds. Good. Thurgood Marshall had a different background. He was the first Black person appointed to this court, I believe, and he had a background when Black people in the South were under legal segregation, and he grew up that way. My goodness, he was helpful on this court to tell people about a few things that the rest of them might not have experienced. So, of course, diversity of background and experience is a good idea, not the only idea. We are judges, and you must be a judge, but an important idea. So we're moving in that direction. And I'm glad that we are, because when it's totally natural, which I believe one day, not too long from now, it will be, then, okay, we can have, we'll still have problems, but there'll be other problems.
Very good. Well, thank you. Thank you, Justice Breyer. And again, thank you for your extraordinary service on the court. We're so honored to have you here at this moment in time. Now, let me just, I'm going to mix between kind of my questions and questions that we're getting from our viewers. So we have a question from Jinrei Zhang, who writes, the Constitution of India, which I have here on my desk, the Constitution of India is very detailed and lengthy, while the US Constitution is much shorter. How does this impact the Constitution interpretation of the 2 courts? So let me start with the Chief Justice and then go to Justice Breyer. Mr. Chief Justice.
Constitutional interpretation regarding the, sorry, what is the issue which you want to refer? Can I have a clarity of your thought?
Yeah, so the Indian Constitution is very different from the US Constitution. It's much more detailed. It's much longer, and whereas the U.S. Constitution is really quite short. So the question is, how does the essentially the type of Constitution impact your interpretation? Do you think a long Constitution and a detailed Constitution gets interpreted differently than a shorter Constitution?
See, the American Constitution, the Indian Constitution, the spirit is the same. The object of we the people of the country must abide by the rule of law, and ultimately it is the public or the people view is sovereign. Now they are we have to respect the people's view, and ultimately we have to take into the actions of the executive or the legislature in a judicial review process, and ultimately we will uphold the constitutional values. We are aware that Indian Constitution, the major judgment about the Kesavananda Bharati, which prescribes the limits of the legislature as well as the executive, and at the same time the judiciary. The theory of basic structure concept was introduced, and thereafter we are following the logic and reasoning of the judgment over a period of years. This is how we interpret the laws and the actions of the executive.
Thank you very much, Mr. Chief Justice.
And,
sorry, go ahead.
One more thing is that there is a clear-cut separation of powers. 3 organs of the Supreme Court, the Constitution, we have mark clearly the roles of these institutions, legislature, executive, as well as the judiciary. So I think there's no problem of interpreting any of the issues.
Very good. Well, thank you. Thank you. Mr. Justice Breyer?
I would pick up one word that the Chief Justice said, or maybe two, and emphasize them. One was the basic values, whether it's long and short, those values are there. And you see in both constitutions that they include a degree of equality. They include basic human rights, such as free speech and free press and so forth. They include rule of law. And we both have the same problem, both courts, in that we are not elected people, but we live in a constitution and under a system where what prevails is democracy. And so how do we protect the basic values where a majority of the people want to hurt them? What is our job and what is the job of Congress? There's no easy answer to that, where you have a short constitution. And the answer, I suspect, is no easier when you have a long constitution. Mm-hmm. There we are. Justice Black used to say, oh, just read the words. It says Congress shall make no law abridging the freedom of speech. He'd say, no law, that's easy. It means no law. And we would reply, those replied to him, said, but Mr. Justice Black, it's not the words no law that cause the problem. The question is, what's the proper interpretation of the freedom of speech? It doesn't mean I can speak by going out and saying, let's all go rob a bank. On the other hand, it does protect political speech. And how do we draw the line and where do we do it? And India has, that's why it's worthwhile knowing what some of these other, or at least paying attention to what these other courts do, which have the same kinds of problems, same kinds of documents, protecting those values, and then see how do they deal with the problem. We don't have to follow it, but we can learn from it.
Well, very good. And actually, let me follow up on your point about conversation between different legal systems. And then I'll begin with you, Justice Breyer, and then follow up with the Chief Justice. So, Justice Breyer, in your 2015 book, The Court and the World, you argued that modern courts inevitably must engage foreign law in our interconnected, globalized world. And you've written that our court should be aware of what other courts are doing. For example, you dissented from a decision to uphold lethal injection in Omaha, observing that 137 countries have abolished the death penalty, and the United States was one of only 22 in the world to carry out any executions at all. Do you recall turning to Indian law at any time? And did your trip to India with Justice O'Connor in 2001 have any impact on your thinking?
Well, in many ways, I liked our trips to India. And not just because Ruth Ginsburg and Nino Scalia had a chance to ride an elephant. I mean, that was nice, but that isn't the main point. You don't know what you're going to learn. You don't know in advance what you're going to learn when you start talking to judges from other countries. Interesting. Yes, it might have helped a little with the death penalty case, but more important than that, I thought, we were there in 2001. We went to Gujarat. We went to Ahmedabad. And one of the judges in Ahmedabad showed me a building, trees around it, a big wooden porch, some rooms obviously within, and a line of women, a queue that must have stretched, it looked like it went on endlessly into those trees. So I said, what's that? And the judge says, we've set up a system here so that women in this area, when they have something to complain about, maybe their husbands were hitting them, maybe their in-laws took what they thought were some of the money belonging to them. There are all kinds of problems they were having. But inside these rooms, there is a psychologist, there is a lawyer, there is a social worker, and they will explain their problem. And those three women who hear the problem will try to figure out how to help them. It might be going to the police. It might not be. It might be bringing a law case. It might not be. But it focuses on those individual problems of those women, and they like it They feel it's helpful. That's why there's so long a queue. So I had a big picture of that, and I had it right over here in my office for about 5 years. And because I knew when people came in interested in different things, some I knew were interested in women's problems, and they'd say, "What's that?" And I would explain it just as I've explained it to you. But I would end by saying, "Of course, we have a system like that here, don't we?" Haha. I knew perfectly well we didn't. And so I thought by saying that and explaining that, they would learn something that would be helpful coming from India. Good. So they'll learn things here when the Indian judges come. We'll learn things there. And all I can tell you is, well, I can't predict in advance exactly what it's going to be, but it's there.
Thank you. Thank you. And let me go back to Chief Justice. I have a question about the higher judiciary in India has innovated quite a few interpretive tools in the spirit of a welfarist constitution. One noteworthy tool is the development of public interest litigation jurisdiction. And as I understand, it allows public-spirited people to advocate for redress when there have been violations of fundamental rights, deficiencies in education and healthcare, or other serious problems. And they can do so in order to advance the larger public interest without strict compliance of locus requirements. So my question for you, Chief Justice, is in contemporary Indian democracy, how relevant is such jurisdiction?
The public interest litigation or jurisdiction was an innovation of the Indian judiciary, particularly the Supreme Court. It is mainly meant for the marginalized people who cannot approach the courts through advocate to expose their cause. The idea is to promote access to justice. You know that initially it started a postcard is enough, or a representation, a letter is enough to take up the cause in the larger public interest. When necessary, the court looked beyond the locus standi to uphold the public interest. They relaxed the public standi locus business for some time. Because of proactive approach of the Supreme Court, the public interest litigation became a tool of empowerment for those without voice. It generated awareness about the rights of the people. Apart from that, the Supreme Court is closely monitoring various issues through this public interest litigation. For example, the environmental issue, long pending the criminal cases against the elected public representatives, protection of human rights. These are the issues, some of the issues which we closely monitor. A continuous mandamus you are issuing. And this public interest litigation has prevented gross abuse of the executive power and checked the corruption in some levels and also sought accountability. Of course, I agree that it has some limitations. Supreme Court and High Court also imposed certain restrictions of the misuse of this public interest litigation. But overall, if you look into the whole scenario, it is the net outcome is more encouraging and positive. Public interest litigation basically is a tool and it's an instrument to uphold the civil rights and to take care of the needs of the people belongs to the suppressed classes. It's I think to some extent it successfully achieved its object. And now it is the integral part of the system. And public interest litigation misuse also there to some extent, but there are good number of judgments where we have regulated the frivolous filing of this public interest litigation, and we are harsh towards those people who want to settle scores or misuse misuse the PAL jurisdiction.
Well, thank you very much, Chief Justice. And again, I think one of the things that's so invaluable about this conversation is to find out in the different legal systems the way different things are done and strengths and things we should be aware of. So, you know, you're talking about public interest litigation is really, I really learned a lot from your answers. So thank you. Now, I'd like to turn to the process of naming judges. And again, first to Justice Breyer and then to Chief Justice Ramana. Mr. Justice Breyer, your new book, The Authority of the Court and the Perils of Politics, talks about, among other things, retirements and nominations to the court. Does the political nature of U.S. Supreme Court retirements and nominations undermine the court's authority?
I don't think much. I mean, it is part of it. It was meant to be. The nomination process is a political process. What I think has been happening, and this is a problem for us, I think, is that take the political party. Different groups of politically organized people have different political views. And they will try to get Judge X or Judge Y nominated to the Supreme Court. But they will think that Judge X or Judge Y have views about law that will lead to decisions that favor their particular political view. So when Judge X or Judge Y reaches a decision, Judge X or Judge Y is deciding it in his own mind or her own mind according to the law. Law is not something that you like physics or something that you can just go and. Law is complex and has to deal with people in living societies. And people see underlying jurisprudential views in different ways. But I think it's important for people to understand that once you be put on that road, and once you become a judge, you might have different views about law, but you're not thinking about politics. You might have different political views because you were raised, say, on a farm, or say you were raised as I was in San Francisco, went to a state high school, Lowell High School, had the life I've had. You've had the life you've had. And after a certain number of years, you have views about what is that word liberty? What is this country like? What is the word in this Constitution? What does it mean? How does it relate? All right, those are jurisprudential views, if you're a judge, that could affect your decision. But that's not what I used to know when I worked in the Senate staff. That's not real politics, which is who's popular, who isn't, are you a Democrat or a Republican? Now, I would like people to understand that. That's why I wrote this recent book. And it's more complicated than I said, but I'll spare you the complication for the moment. And still, the more people understand that, the more they'll be willing to understand that we have a system where people have a voice in selecting a judge through a presidential appointment and a confirmation process. That's going to be political. But the job of judging is not political. You can't say not 100%. You can't say 100% about anything. But it's in very much the non-political direction. And I think this is a moment where it is important for people to understand that. Doesn't mean, by the way, that people who disagree with me jurisprudentially are always right. I might think the opposite. But you have to know the nature of the problem.
Very good. Thank you very much, Mr. Justice Breyer. Your book is very powerful. So let me now move to the Indian model. And Mr. Chief Justice, you've been advocating for the creation of a statutory body for augmenting infrastructure for the judiciary at all levels, and also for filling up of judicial vacancies on an urgent basis. It's an approach that is institution-oriented. So would you please elaborate on how this measure will substantially improve the delivery of justice in India?
First, let me, I really love the statement of Justice Breyer. The job of the judge is not political. It's a wonderful statement. I am very happy to hear from Mr. Breyer about that statement. Once we are taken oath on the Constitution, once we start working on as a judge, I think politics is no more relevant. It is the Constitution which guides us. This is the principle, I think, anywhere. Now coming back to the question that about the judicial infrastructure issue, which was taken up by me as a priority item. The reason is that from the days of my profession as an advocate, I've been noticing the very poor conditions of the courts in particularly rural areas, because I practice from magistrate court to the Supreme Court, all levels. And judicial infrastructure is in India remains one of the most neglected area. After British left the country, most of the courts now constructed by the British. Subsequently, for one or other reason, we have not modernized the courts. So this is the subject which is on my priority list. And after assuming the Chief Justice office, I requested my registry to conduct a survey to know the condition of the courts. The results were disappointing. In the interest of increased access to justice, I had to take up urgent basis on this issue. So I requested the government, I sent a report to the government of India to create an infrastructure corporation at national level as well as the state levels. Because the pandemic has proved that the modern technology has to be integral part of the infrastructure. Now we need a good technology and infrastructure and to carry out the dignity and respect of the court also. So my proposed creation of independent statutory authority at two levels is takes care of the problem of the infrastructure, because such authority must have functional and financial autonomy. It would ensure timely execution of the modernization projects and the uniformity of the standardization. By end of this year, I think this month, April, end of the month, we are holding a conference at Delhi with all the Chief Justices of the states as well as the Chief Ministers of the states, and the Honorable Prime Minister is also, and Law Minister also participating in the conference. I hope that it will take a shape soon. The reason is that the clients are the litigant public, the lawyers, the judicial officers who are working, must work in a good environment. So the results will be good. That is the reason why I have taken up this project as a priority project.
Thank you, Chief Justice. I think that's clearly a very important project. Thank you for your leadership. Now let me turn to retirements and age limits. So you probably have not heard any questions about this, Justice Breyer, but you've served on the court for 28 years. And what are the pros and cons of not having a term limit or mandatory retirement age, which the Indian Constitution prescribes? And what do you think of term limits for U.S. Supreme Court justices?
What I've said for a long time is if it's a long term, it's all right. I've heard a certain number of complaints in India that the term is too short, and that may be, but we don't have any term. And if there were a long term, 18 years, 20 years, I think actually would have made my life easier. I mean, I will retire this summer, but there is not a problem with that. You want it long because you don't want somebody thinking, what is his next job going to be? Mm-hmm. And I will be 84 years old this summer. I don't look a day over 83. but nonetheless, I'm not so much thinking of my next job. It's a long time, that's fine. But it takes time to adjust to the institution. And I suspect that the Indian Supreme Court is similar. It's an unusual institution. And Justice Douglas said 5 years. David Souter said 3 years, or maybe it's the other way around. But the first few years, you wonder, can I do this job really? You might not say it, but you're thinking it. And then you say, well, I can do my best, and that's about it. And you get used to it. That there are all kinds of unsaid approaches, rules, habits, and how the court works. Because it is an institution of government, as well as a court of law. And how do those things combine? And as I said, where does it fit within this separation of powers? And you're talking about, and is it different in wartime than peacetime? That's just one question. See, and all those things that come with you with a history, it takes time to develop your own approaches, your own understanding, your own understanding against the past and what's happened in the past, very important in law. And what will that future be? None of us knows. But we hope that we will have done a little bit of good for the law and the rule of law in the country. All those things are there. And so if you say, would it matter to have a very long retirement period? I'll say no. In many respects, it would probably make things easier. Would it be better to have no period than a short period? I don't know. We don't have any period, so I can't really answer that very easily.
Well, thank you. Thank you, Mr. Justice Breyer. And now let me turn to the Chief Justice. So you are going to turn 65 this August.
Yes.
And
That's nothing.
so for a judge, is that not too young an age to retire? And so that's the kind of the jurisprudential question. And then what are your future plans?
Yes, I think 65 years is too early, an age of for someone to retire. I worked almost 22 years as a High Court judge, Chief Justice of the High Court, Supreme Court judge, now Chief Justice of the Supreme Court. In the Indian judiciary, at the time of joining, we know our date of retirement. There are no exceptions. As for me, I'm still left with a decent amount of energy. I'm a son of an agriculturist. I'm still left with some land to cultivate. I'm basically a man of people. I love to be among the people. It has been my nature since my student days. I hope I will find the right avenue to invest my energy for the sake of people. One thing I can say for certain is that retirement from the judiciary does not mean that I will retire from public life. So I'm now too busy to currently to think about my future retirement plans.
Very good. Well, thank you. Let me go back to one more question. Actually, I have many more questions that we can go through as time allowing. Let me go back to Justice Ramana. One thing that I wanted to ask you about is an aspect of the Indian judicial system that is the legal aid system. And I believe that India runs the world's largest legal aid service under your patronage. Is there a statutory basis for this? Is it totally voluntary? And what's your advice to the rest of the world in this regard?
See, our constitution guarantee the equal access to justice. The Legal Service Authorities Act, which is the act, was in fact enacted in 1987 for this purpose. Now we have a statutory legal service authorities, the bodies both at the government of central level as well as the state level. The legal service authorities provide a wide range of services. They conduct legal awareness camps, provide the ADR facilities, offer services of counsels in both civil and criminal matters. Through these authorities, the legal aid is now available more than 80% of the Indian population.
Hmm.
We have around 45,000 paralegal voluntaries. There are nearly 12,000 legal service clinics functioning all over the country. And our experience in this area is very encouraging. The pre-litigation settlements and mediation left to lead to reduction of number of cases coming to the courts. Providing legal aid to the under trials is another significant contribution of these authorities. We have legal service clinics in jails as well, which provides assistance to the under trials as well as the convicts. The Indian legal service model can be replicated anywhere, particularly in the developing countries. This is a very successful enactment and a movement. Legal aid movement is very popular in this country because poverty and other reasons, the people who are unable to approach the courts, who are unable to engage lawyers, to spend money for these expenses, etc., that has taken care of by the government. It's a great success. That much I want to tell you that, and it is headed by I am the patron in chief, and my next judge is the second judge, is the chairman of the central committee, and at state levels, the chief justice and number one next judge is the in charge of these committees. We have up to lowest level of village level, up to village level, there are committees on to provide the legal help.
Well, very good. And I think it's very, it's very helpful for us to again learn from the Indian system. Among the areas that we've talked about are public interest litigation and legal aid, and the very different models, as well as thinking about the mandatory retirement age, and again, very different from the U.S. model. So let me actually shift now to thinking about international legal education. And this is a question from Yi Song, who's the executive director of Georgetown Law's international graduate programs. So she asks, she says, Justice Breyer was, of course, a legal educator for many years, and Chief Justice Ramana, you visited the United States to examine the U.S. legal system. Yi Song asks, what are your views on educating international LLM students in the U.S.? How can our students return home and initiate the bottom-up grassroots changes in society that currently do not observe democratic values such as freedom of speech, separation of power, and checks and balances? So this really focuses on kind of what we at Georgetown, as we are educating students who will, return to India or other countries, what should we be focusing on in terms of their education and, how they could initiate grassroots change to the extent that it's, something that, would advance important values. So let me begin, Justice Breyer, with you drawing on your experience as an educator. Do you have any thoughts on international graduate education?
Well, I can't write a curriculum for you. I can say that I think it's important, but there's a model for me is the Erasmus program in Europe. The Erasmus program, which the EU started really, takes students and they might spend a year or so in a different country. Good. It's not all going to be spending it in the US or, for that matter, in India. I don't mind. Go to a different country, see how other people live, see what their legal systems are like. And to know in advance how you can help is something beyond me. You don't know in advance. Mm-hmm. Life has a way of coming in and it offers you some opportunities. And if it offers you some opportunity to help people achieve a better life, good, take it. That's trite, but true, that you don't know. Mm-hmm. So the thing I think you teach in your country, and the only thing that's made, second thing that's made me slightly sorry is I'm sorry there's a special program. I would like somebody to come to this country, or some students go to India, or they go to France, or they go to Germany, or they go to Britain, wherever. And what they do is they see how the law works there from the point of view of a person living there. Mm-hmm. And then that helps them. Maybe they'll practice some over there. Maybe some will come and practice here. There will be a tie. There will be a link. There will be an understanding. And if that understanding takes place in a country that values rule of law, which they will, Many will, many people will, and these other basic human rights values and so forth. Fine, fine. But your job is primarily to teach them the law, and to teach them respect for the law, and to teach them what a rule of law is and what it isn't in the country that you happen to be teaching in.
Well, thank you very much, Justice Breyer. And Mr. Chief Justice, any thoughts on what we should be doing as we educate our international students?
I welcome that this learning in a different land, different country, exposing yourself to different culture or different system of teaching is a good experience for a upcoming lawyer particularly. Foreign education, always this experience and exposure will help a lot. It is two-way benefit. Every country should encourage and sponsor this education. It is holistic learning. Learning is never confined to classroom. So if you come to India or we come to America, it has a lot of exchange will take place. Apart from that, we'll understand the systems. We can contribute a lot. If we learn something there, they can come and work here. If you see now the present participant, Ms. Viva Makija, who is also a student of your university, and they are all contributing a lot to the Indian judiciary. And in fact, we appreciate the efforts she has taken from the last so many days. Particularly, she insisted me that we must have a conversation with Mr. Justice Breyer and all of you. So we learn a lot of things. It's a good thing, and different cultural activities, different teachings, different values. It is a wonderful thing for us to learn. Our registrar, Mr. Jaggi, who is a now computer registrar, is also from your university. And these people are working wonderfully and helping me in administration. I'm happy the good products of your university.
And I think, it's interesting hearing both of you. One of the themes that I would take from it is the importance of dialogue and learning from each other. So it's these conversations like between, justices of the two courts, have a kind of a similar focus as what we and other law schools around the world are trying to do with kind of international education. Now, let me go to a few other questions that are coming in from our audience. One audience member asks, why is abortion so politicized in the United States, but not in India? Actually, let me start with the Chief Justice and then Justice Breyer, if you'd answer that question. Mr. Chief Justice?
Abortion is not, honestly saying, it's not a major issue in our country. The reason is that normally Indian population, particularly women, our marriage system is altogether different. So it is expected that after marriage, the consent of husband, they lead the family life. If there is any difficulty in the conceiving child or delivery of the child, etc., these issues can be in consultation with the family, they take a decision. And the issues of sex before marriage and other issues is not that serious in this country. That there are negligible instances where we can look into it. That's why I think abortion, right of abortion, and all those issues are not that focused issues in India.
Thank you. Mr. Justice Breyer?
Oh, I think that's a question you should ask a political person. I mean, they would have a more sophisticated answer than I. And then the only thing I could contribute, I guess I did write this in an opinion, is that the question before us is not whether abortion is a good thing or a bad thing. There are different opinions among different people on that. and they feel them very strongly, very strongly. And the question is, what kind of law is there? What kind of law is there in a nation which has large numbers of people feeling differently about a question like that? That isn't about moral rights or moral wrongs.
Yeah, thank you. Thank you. Chief Justice Ramana has advocated for affirmative action in the appointment of judges. And I'd like to ask you both, and again, starting with the Chief Justice and then Justice Breyer, could you speak to the concept of merit in the appointment of judges and justices? Mr. Chief Justice? And again, this is a question from our audience.
Right. The Constitution of India mandates separation of powers between the three organs, which I have already indicated. Judiciary is mainly mandated to review the executive and legislative actions. That's why Indian independent judiciary is non-negotiable. It is the courts that uphold the fundamental rights and the rule of law. People will trust the judiciary only if it acts independently. The decisions of the Supreme Court on judicial appointments are aimed at sustaining people's faith and trust. Interpretation of the constitutional provisions regarding the appointments of judges had to be undertaken by the Supreme Court only when it felt that there was executive overreach. In doing so, the Supreme Court followed the basic structure doctrine. Apart from that, there is an impression in India, judges appoints judges. It is a wrong impression, and I want to correct it. The appointment is done through a lengthy consultative process. Many stakeholders are consulted. The executive is one of the key stakeholders. For example, let us look at the process of appointment of a High Court judge, a constitutional court. Once the proposal is made by the court, it was sent to the concerned Chief Minister of the state, and then it's the governor. They are entitled to examine the proposal sent by the court, and thereafter they forward the recommendation with their views, either objecting or supporting, to the Government of India, the Law Ministry. And the Law Ministry, after obtaining necessary inputs, taking into consideration of the antecedents, reported judgments, etc., they will forward the views to the Supreme Court Collegium. Chief Justice and two senior-most judges of the Supreme Court, after obtaining the consultee judge's opinion. Consultee judges means the judges earlier, if they worked in that particular state or familiar to that state affairs, their views also be taken. After all that, taking the views, we place the matter before the three judges, that is Chief Justice and two senior-most judges. We will recommend the names to the top executive, that is the Prime Minister. There is another step of the scrutiny by the Government of India. Then it was ultimately sent to the President of India. It's a long-run process, and we will consult at every stage. The consultation takes place. I do not think this process can be more democratic than this. And the fact that the government, which finally appoints the judges in the name of the President of India, that is head of our state. I said earlier that sustaining people's faith in the judiciary is the guiding principle. It is true that sometimes where the government can raise objections about a particular appointment, if they send back the proposal, return back the proposal to the Supreme Court Collegium, we will look into the material placed before us, whether the reasons are valid or there is any substantial material of rejection of a particular candidate or not. And if we satisfy the inputs, then we'll reconsider, otherwise we'll reiterate. Once we reiterate second time, the government has no option, they have to appoint. This is what the sum and substance of the procedure which the present system which we are following.
So I have to say, it's really fascinating to hear about the procedure and the process that you follow in India. And this is, we're unfortunately we're really out of time. So let me turn to you, Justice Breyer, for the final question on your thoughts on merit and judicial selection.
Merit. My brother says, who's a federal judge in San Francisco, he says, sitting next to a federal judge at dinner, you want to know what should you talk about? Just say, how are you appointed? He said, you won't have to say another word throughout the rest of the dinner, except you'll get the impression that the judge thinks his was the only, or hers was the only merit appointment. It's a political process appointing a federal judge. But at least I believe through now, it's been in the political interest of those involved to appoint a person who is a qualified person on the merits, on the law, knows how to be a judge. And you can look at instances where that hasn't occurred, and they paid a price politically for that. So merit always, until now, I think plays a role, sometimes a little more, sometimes less, often a critical role, because when that criterion isn't fulfilled, it gets the appointing authorities into trouble. All right? But will it continue? This is what I say to the students. I say that question is like so many other questions about cooperation and ending division in this country, or limiting it and trying to get together what Americans are supposed to be good at, working together. I said, you know what it depends upon? I say to the students, it depends upon you, my friends, because, what happened?
We can hear you. We can't see you.
Okay. What I say to them is, I'm very sorry, but this Constitution will work, in my opinion, and in the founders' opinion, only if you and your friends over the next umpteen years decide to participate in public life, decide to listen to people who have different points of view than you, decide to discuss these matters with other people in ways that are calm and listening and not overly excited. And then you might try to convince them, and they might try to convince you, and you will find areas of agreement. In other words, what we learned in the 5th grade in Grant School in San Francisco about working together, and you learned in your grammar school classes, put it into practice, because that depends upon you. And if the you goes out and does that, I'm not too worried about merit appointments. They'll be there.
Very good. I think that's these final comments from the Chief Justice and Justice Breyer are really such powerful ways to end, because it really reflects, I think, the underlying idea here that, first of all, we're learning from each other, we're talking to each other, seeing where we're commonalities and differences, and thinking about the best way to move forward. And I think I'm particularly interested in that we're having this conversation with ourselves and with the legal community and with the next generation of lawyers. So powerful. And this is historic. Actually, when Viva Datta Makaija first broached this idea, I thought, this is a dream. And today it's become a reality. So I want to thank both of you. And then pass over to Viva. Sorry, Mr. Chief Justice.
Just I want to make one thing clear about this abortion issue, which I could not, I think, properly respond to. I want to say a certain one thing, just to make it clear before concluding, that in India, there are regulations are there to stop acts of female feticide, and apart from that, at last, it is a balancing act of right to life of a child versus right of the mother. Autonomy of the body of a female is important. This issue, which I want to clarify, because I think I have not responded that issue at that time.
Yeah. No, thank you very much, Chief Justice. Thank you for concluding on that important point. And again, thank you so much to Justice Breyer and Chief Justice Ramana. And then I'd like to bring for concluding comments to the woman who has made this all possible, Viva Datta Makija, one of our graduates. Thank you, Viva, and let me turn to you for the close.
Good evening, everyone. Thank you. Good evening, everyone. And thank you for such a scintillating conversation. I have to thank both Justice Breyer and Chief Justice Ramana from the bottom of my heart to agree to come to this conversation on this platform. In fact, it's most important for the students and young people to hear conversations like these from the highest levels of the judiciary and across the globe, because what we are finding here is that the ideas are the same. It's just how they are packaged that's different. Thank you so much, Chief Justice Ramana. Thank you so much, Justice Breyer, for being our honored guests. I also want to thank Dean Bill Traynor, without whose consistent support we couldn't have brought this through. He's the one who has coordinated and ensured that both the Chief Justice as well as Justice Breyer meet on this platform. Also, Associate Dean Madhvi Sundar, who has been seminal in this entire process. She has followed everything up to the T. I would also like to thank the entire Georgetown team, both at the Dean's office as well as the tech, and also my team here at SDR. And also, I think from Justice Breyer's office, Tony has been very, very proactive in getting us the dates to put together these two great men on the screen for all of you. And of course, last but not the least, the entire audience, which is a fabulous audience that we have here. And I do wish that we meet again in the next set of these series. Thank you so much, all of you, to be here to join us at this momentous event. Thank you all.
Thank you. Thank you very much.
Thank you.
Thank you, Dean. Honored to be here.